Well, a few people ask if we can do something about private prosecutions, and as always, your wish is my command. So, what is a private prosecution? Well, as the name suggests, it is where somebody brings a prosecution, but they're not the CPS or the state. And private prosecutions are quite common. I mean, for instance, the RSPCA prosecutes a lot of animal cruelty offences, and they do that as a private prosecutor. I mean, arguably, like the HMRC, they bring prosecutions sometimes, and again, they're a private prosecutor. The only state prosecutor, really, is the Crown Prosecution Service. I've mentioned before, prior to 1984, when the CPS was created, prosecutions were brought effectively by the police, so arguably they were all private prosecutions as well. So who can bring a private prosecution? Well, any adult, and you can also bring them on behalf of companies. So how do you go about this? It's what we used to call laying an information. That's the old term for it. But essentially now you just fill out a form. It's called an application for summons or warrant for arrest for alleged offence. We have a thing called the criminal procedure rules. And if you want to know more about this, it's Rule 7.2 Sub-Rule 6. Okay, but hopefully I can give you sort of like the bare bones of this. So you fill the form out. First section is you put who you are. You know, this is an application by you or the company. And you put all your contact details on there, you know, sort of address, phone numbers, email, etc., etc. You then list what offence or offences you wish to prosecute. So, you know, theft, assault, or whatever. You just have to put the bare bones of the, you know, the name of the offence there, because you'll give more details shortly on the form. You also have to say who the proposed defendant is, and you put all their contact details as well. Now, there are some offences that require the consent of the Director of Public Prosecutions to prosecute, and if any of the offences fall within that category, you have to write to the DPP and say, I wish to bring a private prosecution, do you consent? And if they say yes, then you tick the yes box and you attach a copy of that consent. But for most offences, you don't need the DPP's consent, so you can just sort of, you know, plough ahead. You have to say if you've made any previous attempts at prosecuting this person. The mere fact you have doesn't necessarily mean you can't do it again. You know, say for instance, you got something wrong the first time, or they're able to strike it out. That doesn't stop you going ahead. The only exception to that is if somebody was dealt with and they were either formally found not guilty or convicted. It's what we used to call atrefroid convict or atrefroid acquit, which means, you know, I have already been dealt with. And, you know, we have the double jeopardy rule, which means you cannot be prosecuted twice for either the same offence or for offences arising out of the same factual situation. You also have to say if you're aware of any other proceedings against the same defendant for offences arising out of the same facts, and if that is the case, you have to list, you know, where it's being prosecuted and who's dealing with that one as well, because, like I say, you know, you can't be prosecuted twice for the same offence. So if there's multiple people, like, you know, trying to go after the same person, there may need to be some sort of discussion about who actually gets to carry the case forward. You also have to set out the actual circumstances of the offence, you know, the actual details, you know, who was involved, where it happened, how it happened. Because, you know, when an indictment is drawn up, you have what they call the statement of the offence and the particulars of the offence. So it will say something like, statement of offence, theft contrary to Section 1 of the Theft Act 1968, particulars of offence, on such and such day, went into such and such corner shop and stole a Mars bar. So, you know, you give quite a, you know, a level of detail there so that people know exactly what they are being accused of. You also have this thing where you can't have what we call duplicity, which means you can't put details down for one offence where arguably there's lots of different offences in there. So you couldn't say something like theft, and the particulars of the offence are he went into one shop and stole like 3 tins of paint, and he went into another shop and stole a load of paint rollers, because it's like you need to be able to plead, well, I can plead to that one, but I can't plead to that one. So yeah, so if there's multiple offences, then you have to list each one separately. You then set out concisely the evidence you would like to rely on to actually prove this offence. So, you will like, list any witnesses and what they say they saw. If there's CCTV, you'll put that. So, just basically all the evidence that you would seek to rely on at court, assuming it was admissible. You don't get to rouse about admissibility at this stage. You just say, this is everything we have. So once you've done all that, the court they will send a copy to you, but they will produce a summons which will be sent to the defendant saying you must attend at court for your first appearance on whatever date and whatever time. What if, however, you don't actually know where the defendant lives or how to get in touch with them? Then you can actually apply for a warrant for them to be arrested. Obviously, that's a more serious step, so it only applies where it's an offence that is triable on indictment. Either it has to be tried in the Crown Court, or the magistrate's court could send it to the Crown Court, or the defendant could elect for it to be tried in the Crown Court. But if you tick all those boxes and you explain why, you can't find this person, and you have to say, what efforts you've taken, then they will issue a warrant for that person's arrest, and the police can go and arrest them and produce them and say, right, you must be in court on this date. Usually they will obviously bail them. But, that's sort of quite a significant power. You then sign the form. There's a declaration where you say, to the best of your knowledge and ability, everything in this is true. Sometimes the courts might actually say, can you come in and just confirm this on oath? Because obviously, it's a very serious situation, so they don't want people just doing this, on a whim or vexatiously. But what happens next? Well, like I say, there is a first appearance and somebody comes to court and the charges are put to them and they can indicate guilty or not guilty. They can, however, argue that the prosecution shouldn't go ahead, that it should be struck out as an abuse of process. So what's an abuse of process? Well, you should be applying the same test the CPS does. Is there a realistic prospect of conviction, and is it also in the public interest for the prosecution to go ahead? Now, actually, there is some authority to say that actually that second limb isn't quite as significant in private prosecutions. However, in practice, courts do not want people just using this willy-nilly. I mean, don't get me wrong, they're quite happy for people to do private prosecutions, and lots of cases are done as private prosecutions. But there can be an argument about this. But let's say, the court says, no, this is not an abusive process. What happens? Well, it's just like any other court proceeding then. The person, the charge is put to them. They plead guilty or not guilty. If it's a summary-only offence, in other words, one that can only be dealt with in the magistrate's court, then it will be listed for a trial, or possibly for, the directions hearing beforehand. If it's, an either-way offence, one that can be done in the magistrates or the Crown Court, well, first of all, the magistrates say, well, we think we can deal with this, or we don't think we can deal with this. If they say they don't think they can deal with this, it will be sent to the Crown Court. But even if they accept jurisdiction, as we say, on an either-way offence, the defendant can say, well, I elect a jury trial. I want to go to Crown Court on this. So then the prosecution goes ahead. But one thing to remember is, because you effectively have all the same powers as the state, you also have all the same responsibilities. So you have to, do all the disclosure properly. You have to serve the evidence. You have to serve the unused material, and that's something that you might want to get legal advice on. I mean, you don't have to do these on your own. You can instruct lawyers to actually bring the private prosecution, on your behalf. But yeah, you have to sort of tick all the same boxes that the CPS would have to do. But yeah, then it just goes for trial. Now, one thing to remember, although this is a private prosecution, you can instruct lawyers to conduct that prosecution on your behalf, and that's usually wise, especially if it's going to be something that ends up in the Crown Court, because, like I say, the obligations are sort of quite onerous. Also, there are certain things with like vulnerable witnesses where they're only allowed to be cross-examined by professionals, who know the rules about how to deal with vulnerable witnesses and people like that. I mean, you could actually do most of it yourself and just get in counsel to do the bits that you're not allowed to do yourself. Okay, so eventually the trial goes ahead. Let's say the person is convicted. What happens then? Well, obviously, they get sentenced. But what about the costs? Well, with a private prosecution, if there is a conviction, either in the magistrate's court or the Crown Court, you can apply for your costs of bringing the case. And that includes the investigation costs as well. I mean, whether you get all of them or whether you can recover on those is another matter. But you can apply for those. What if, however, there is an acquittal? Well, if there is an acquittal in the magistrates' court, the defendant can apply for their costs from central funds. I mean, they don't get all their costs, they just get them at legal aid rates. But the thing is, they don't come after you for them. That's the interesting thing. Same in the Crown Court, the defendant can apply for their costs. However, in the Crown Court, even if you are unsuccessful in a prosecution, the prosecutor can still apply for their costs from the state. That tends not to be the case in the magistrates' court. If you lose in the magistrates' court, it's well tough. But yeah, in the Crown Court, you can ask for your costs to be paid even if you lose. You may also have heard of like what we call confiscation proceedings, all this proceeds of crime stuff, where you chase after the person for, the money that they made on the back of their criminality. And it's not even profit, it's just turnover. It doesn't even matter if they don't have it anymore. There can still be an order made against them that, yes, this is how much they benefited. Now, technically, that money goes to the Treasury. However, there have been some rather controversial cases where they've split the money between the Treasury and the prosecutor. This crops up a lot because a lot of people who own like intellectual property, big companies like Virgin Media, they've gone after people, privately prosecuted them for copyright infringement, and then done deals on, to basically go after them also for the confiscation proceedings. And it's like, look, we'll go to the expense of running all this, and we'll pay the lawyers to do it, but we'd like to keep some of it. We'll give some of it to the Treasury, but we'd like to keep some of it. So yeah, that's another incentive for doing these. So you can see the upside in terms of, the cost implications. What are the risks and downsides, though? Well, if you bring a prosecution that shouldn't have been brought, then you do risk being an action against you for malicious prosecution. And the test there is that, there has to have been an acquittal, and you have to show that there was no basis for bringing the case. However, if you've survived like a strikeout application, then malicious prosecution claims are quite hard to bring unless somebody could show you tampered with the evidence or you knew from the start that this person was innocent. But that is a potential risk to think about. Another potential risk is that while criminal proceedings are dealt with by laying in information, there are some things where you bring a complaint and they're dealt with slightly differently. I mean, this is a very technical area, but certain things under the Environmental Health Act for public nuisance, some offences are brought with by means of laying in information, but some are done by complaint. And the risk with the complaint is that actually in those things, because they're more sort of regulatory, the civil rules on costs apply. Loser pays winner's costs. So it's very careful that you check exactly which offence you are prosecuting, and don't ask me how I know that one. Another thing to remember is that the Director of Public Prosecution always has a right to take over a private prosecution, and then they can either proceed with it or they can discontinue it. And while that decision is reviewable by judicial review, it is a complicated and expensive procedure. But generally speaking, if a case is properly brought and they think it's within the capabilities of the private prosecutor, they will let you run with it. They may step in if they think actually this is a sort of it's a very serious offence and there's a bit of a technical element and it's in the public interest that this is prosecuted professionally. Then they may take over. Then when might they take over and dismiss? It could be that they just think it's not in the public interest. More often, though, it's because they think it might cause problems. It might interfere with other investigations. You prosecute somebody and actually they're under investigation, and the CPS have been spending years building a massive case against them, and you suddenly come in and sort of I won't say spoil it all, but you cause them problems. Because sometimes when they take over and they just discontinue, you go, "Oh, what's that about then?" And it's like, we can't tell you. Well, that's a bit of a clue for you there. So yeah, there you go. I mean, that's obviously a very brief overview, but to be honest, there's not much more to it than that. I mean, all the technical stuff is how you actually prosecute a case. But like I say, yeah, bringing a private prosecution, it's relatively straightforward. In terms of cost implications, it's a lot better than bringing civil proceedings. But yeah, hope you found that useful. If you did, please consider clicking the like button, subscribing, and sharing.